All rise. Court of Appeals for the State of Kansas is now in session. The Honorable Judge Stephen T.
Please be seated. Good morning, everyone. I think it's been 2 years since I've had real live counsel in front, ready to argue, and I'm looking forward to this. This is the June docket of the Kansas Court of Appeals. My name is Stephen Hill. I am the presiding judge for this panel. I would like to introduce to my right our newest judge on the court, Angela Coble. She is raring to go. Might have a few questions for you, I don't know. And to my left is a grizzled veteran of the Court of Appeals, our senior judge, Pat McInerney. Counsel, we have 2 cases set this morning for oral argument. After this argument, this first argument, we will take a short recess and rearrange some things because the chief judge will be coming in and making her appearance in this second oral argument. So the first matter that we have today is 124-116, John Holliday versus Tamara Holliday. If you would, counsel would take your places. I can tell everyone that we have read your briefs and we have received a research memorandum from our research staff concerning your cases this morning. 15 minutes per side is not very long to make an argument, so I suggest you get right to your points that you want to make. And please allow us to ask you a few questions because sometimes we need clarity. For the appellant, could I have your appearance, please?
Please, the court, Sean Miller, on behalf of the appellant.
And do you wish to reserve any time for rebuttal?
I would like to reserve 3 minutes, please.
3 minutes, you have it. And for the appellant?
Hey, please, the court. The appellee is Tamara Holliday, appears by counsel Cecilia Mariani.
Cecilia Mariani. Okay, very good.
5 minutes for rebuttal, please.
Is there a cross appeal?
No.
There will be no rebuttal.
Oh, I apologize.
She will have the rebuttal. I have been advised that we are live streaming this on YouTube. So counsel, if you want to approach the lectern, we will get your time started. You may proceed.
All right. Good morning. May it please the court. My name is Shauna Miller and I represent John Holliday, the petitioner and the appellant in this case. I know that the court's familiar with the facts of this case, but I want to run through the timeline just briefly because it is rather important. I would note that on October 27th, 2008, John Holliday filed a petition for divorce, which was ultimately granted after trial by a court-ordered decree of divorce and memorandum decision, which was dated July 30th of 2009. Specifically related to the asset that's at issue in this appeal, the court ordered that Mr. Holliday's Capers retirement account be divided 50-50 with evaluation date, the date of the filing of the petition for divorce. So,
Now, as I understand it, that's all of the information
yes,
that Capers needed to know what the division was
yes,
and the date of division.
yes,
Because if your men continue to contribute to the retirement fund,
yes,
those funds would not be covered by that division,
that is
correct?
correct. Yes.
What did the trial court do wrong?
So I think what the trial court did wrong was ultimately Mr. Holliday filed a motion to extinguish this judgment because the decree of divorce, or in essence, which would have been the same thing, the quadro. And so to back up for a second, the Respondent was ordered to complete a quadro in this decree of divorce and deliver that to Capers to reserve or preserve her right, if you will, to the portion of Mr. Holliday's Capers.
Now, the law loves acronyms, and we all use them every day.
Okay.
But for the sake of precision,
Yes,
you made a qualified domestic relations order as contemplated by the ERISA,
yes.
which is the employment.
Oh, you put me on the spot. Employment, let's see, employment, retirement. I didn't write down. the
Income
acronym, but
Security Act.
Thank you. So she was ordered to complete this quadro and deliver it to Capers to preserve her portion of that. She never did that. And so
How do you mean
really-
preserve?
I'm sorry.
Why did you use the term preserve? How did that reserve? Because the judgment was final, wasn't it, between the husband and wife, 50-50. The
Yes.
split's done. That
Yes.
wasn't appealed. That was
Yes.
never changed.
Correct.
So why do you say it was preserved?
So the judgment was
Not
final. The problem is under 60-2403, you must do something with that judgment. It can't just sit there in district court because Capers knows nothing about it. There's no way to actually execute on this judgment until it's delivered to Capers. And that's where a respondent failed because she never delivered this quadro, or in this particular case, we know that it was sufficient. The decree of divorce was sufficient for Capers to interpret. So an actual quadro wasn't needed. But it was her failure to execute or deliver this judgment to Capers that was fatal in this particular case.
Are you then equating the delivery of a copy of the divorce decree to the Caper trustees
Yes, yes,
as the equivalent to suing out an execution on any other judgment?
essentially, exactly. That's what I'm arguing. Yes.
And is it Livermore or Larimore? That's right.
Yes.
Under Larimore, under that ruling, then that judgment has extinguished because nothing like that happened within 5 years plus 2, which is the 7 years. Is that correct?
That is correct. That's the crux of our argument. Yes.
Are we bound by Larimore?
I believe in this particular fact scenario, yes, you are.
Oh, really? It
Yes,
was done by another panel of the Court of Appeals.
yes.
It is at best horizontal precedent. It's certainly not vertical precedent, is
Okay.
it?
And perhaps that was a play on words. You're not maybe legally bound by it, but I believe that the Larimore decision is the correct decision. And I'm asking this court to follow that decision because it is correct.
There's been a lot of criticism of the Larimore decision. Do you want to address that, or should we be concerned with that?
I'm not at all surprised that there is criticism of it. If you will, it's a bit of a harsh ruling perhaps, because
A bit of a harsh
statute-
ruling, yes. I mean, under Larimore, if we follow that, this woman loses half of the pension that she was awarded in the divorce case.
I understand that. However, it was due to her mishap of not following through with her judgment to, as I use the word, preserve it or file that with Capers. 60-2403 requires strict compliance with that statute in order to preserve your judgment. So while the outcome may be harsh, I believe that that is the outcome that's warranted under the statute.
Does the nature of the Capers account itself give you pause to think here? Because your man is Holiday, right?
Yes,
He's not entitled to any of that money that he is in Capers until when he
so he
retires.
either retires, dies, or leaves that employment.
So why shouldn't the rule be that when he retires, then she must have filed the divorce decree within 7 years of that date?
That's simply not the holding in Larimore. That's not the logic in Larimore. The judgment itself became final once it was granted by the court. The judgment itself doesn't attach when he retires, dies, or leaves that employment. The judgment attaches when it's issued by the court. So that's when the date starts ticking.
But aren't there cases that say on time to accounts? The judgment doesn't apply until served?
I think what you're referring to is, for example, the holding in Strom, where that was found to be essentially a monthly obligation. The judgment in that was found to be different than the type of retirement account or judgment in Larimore, or also in this court's Smith case. Also, there's another case, Porterfield, that deals with retirement accounts of this type. Strom is different because we were talking about a monthly obligation that was payable through, I believe it was petitioner in that particular case, through petitioner specifically. So the court in that case found that that was a distinguishable situation. Again, I believe that it's completely distinguishable for the case that we have before the court today.
There's nothing functionally impossible about Capers going back, even without having the decree. And at a much later time, if we don't consider the statutes and reconstructing what the amount was in the account as of the date of the filing of the divorce, which I think was the cutoff date for determining all this.
Right. There is
And
nothing-
dividing up the principal and letting future contributions be only into the who is now former husband's account. I mean, it's functionally possible to do that.
It is still functionally possible because we know the date that this judgment was granted. They can go back, see what the numbers were on that particular date, and then divide it accordingly.
So the real issue is not whether it could be done, it's whether it simply has lapsed. The
Correct.
judgment's lapsed because of the passage of time and the failure to execute on the judgment.
Correct. Correct.
Which would apply, I assume, obviously, if the in a divorce, it's not, there's nothing unique about a divorce case in this respect. I assume if the court had just entered a money judgment against, say, okay, wife, you get the house, husband, you get, she has to write you a check for $50,000. That kind of judgment would be one that the statute would clearly apply to, wouldn't it?
Exactly. If I'm following what you're asking, the only types of judgments obviously that would be precluded by 60-2403 would be like child support obligations, alimony obligations, which this is not. This is different than that. Right. Unless the court has any other specific questions, I think I've argued what I've needed to so far, so I will turn it over to Appley.
Well, counsel, we punish no counsel for not using all of their time.
Very good. Thank you.
All right. Counsel, if you give me a moment here. All right, counsel, tell me, why did the court get it right?
Because Capers came and testified. Kathleen Billings gave a very excellent thank you to the appellee for calling Kathleen Billings to the trial. She gave an excellent presentation on how Capers works and how Capers makes its decision, and that it's Capers, the administrator of the plan, that decides whether the piece of paper that was filed with the court as a domestic relations order is a quadro. In family law, we have this mystery regarding quadros and that there's some magical document that has to be filed. From Capers' perspective, because they are state law and they are bound by two things, the Capers Act and IRS Code 414P. That's it. ERISA doesn't even come into there. It gives guidance, but it doesn't come into their determination whether a piece of paper signed by a judge, entered by the clerk, is a quadro. And in this case, it had all the information that it needed. And you talked about in your question, appellant mentioned the date of the judgment. There's actually a little bit more language in that decree that gave Capers, that kind of put it over the top, in my opinion, and that was the date of the filing being the date of valuation. It gave Capers that last piece of information to tell them where to start and where to stop for Ms. Holliday's portion of the retirement account. So the court got it right.
I guess it's puzzling to me why a copy of the divorce decree wasn't just sent to Capers.
It was.
When?
April 3rd of when I received the motion to extinguish. I immediately sent the decree, certified mail to Capers.
Well, more than 7 years after the date.
It was.
And the judge in the ruling said something that, well, since I don't understand what the judge was saying about that was within 7 years. What does that have to do with anything?
Well, the argument was that the 7 years, the 5+2 in Larimore or in the extinguishment statute, because you get 5 years for the judgment itself, and then you get 2 years on reviver. And so that adds up to the 7 years. So he was addressing.
Judgments become dormant and you've got to do something within that 2 years or it's extinguished.
Correct, or it's extinguished after 7. So he was addressing that argument when he said the 7 years. And we were addressing the argument when we said 28 days, because it was 28 days from the date of the trial to his opinion, that his memorandum that was filed with the court. And so
Are we bound by Larimore? I ask your opposing counsel.
you don't have to go run afoul of Larimore, because the judgment was the quadro and it was filed 28 days.
Well, the district court distinguished Larimore said it didn't apply simply because that Larimore clearly was an action dealing with a quadro.
Correct, but it was also dealing with ERISA. And ERISA is a different animal when it comes to what it requires to overcome its anti-alienation provisions. It requires something more than a couple of words in a divorce decree. Now, other courts have found that a quadro can be a couple of words in a divorce decree. In one of my cases, one of the cases I cited, Festini Steel versus ExxonMobil, literally a check mark in a box on a form divorce decree, setting aside the life insurance policy of the husband, was enough for the court to find it was a quadro. So ERISA has, and we don't know whether, because it doesn't get to us, it doesn't get to a determination of ERISA. We don't know whether an ERISA bound administrator would find that there was enough in the decree to find it a quadro.
This isn't about ERISA.
Correct. It isn't about ERISA.
It's simply dealing with the law of judgments in Kansas, isn't it?
Well, correct. Yes. And the fact that the administrator accepted the quadro and acted on it.
I'm struck by the nature of the property that Capers has. Has your man retired, or has Holiday retired officially now? Okay.
And I'm sloppy on the record of, I didn't get how to enhance or add to the record on appeal that they have distributed. They sent her a check.
So counsel, how do you get around, what's your view of execution? I mean, is execution the registration or the mailing of this decree to the administrator? Is it just the filing? I mean,
I believe.
when is that execution required?
When is the execution required? Within 5 years, but the execution was perfected when the judge entered the order. When Judge Elder signed that order, found it to be fair, just, and equitable, signed off on it with enough information. Now, had that order not had the information in it sufficient for Capers to make their decision and accept it as a quadro, we would have a very different argument. Had this been an ERISA-driven pension plan, Goodyear, Boeing, Vanguard, something like that, we may be having a very different argument, because they would be bound by the administrator not accepting the divorce decree. You needed something else, that you needed to file the quadro. But the courts and the developers and the enforcement interpreters of quadros have said, even just because the wording of having to order a quadro isn't enough, isn't prohibitive of calling the divorce decree the quadro. Capers found that the divorce decree was the quadro, and the court found that the divorce decree was the quadro.
Are pension plans divisible before they're perfected?
When you mean perfected, before they are,
Well, before somebody retires.
yes. Some of them are. I would argue some of them are. I don't believe so. She testified, Ms. Billings testified that you can't use your caper's interest to get a car. You can't use your capers. Capers has an anti-alienation provision in and of itself within the statute. Can't be attached for creditors. You can't use it as on a bank note. You can't use your interest. And she couldn't use her interest either. She couldn't say, hey, I know I'm going to have my ex-husband's capers, because if he dies, she gets nothing.
So basically, if we look at the divorce decree, the original divorce decree, you're telling us that what was divided by the court was a future interest.
That's a term of art that, yes, I
But
guess.
we
it
are
was a-
dealing with laws.
I know, and getting in the weeds of accounting and calling it a future interest. It is an
Well, if they can't use it,
correct.
what is it if it's not a future interest?
I'll go ahead and say it's a future interest, but I worry that I'm using the wrong term. Because it doesn't perfect, and I may be misusing the language, because it doesn't perfect until he says, I'm ready to retire. Because if he didn't retire, it would never come into play and she wouldn't get anything. If he never said, I want to retire, if he never turned in his retirement, she wouldn't get anything. If he dies,
If he doesn't, I don't, explain that to me. He drops dead, she loses her interest
yep,
and capers keeps
That's
the
what-
money.
that's why we have a joke in family law when and I typically represent women, forgive me, but when a woman says after her divorce, well, I just want him to drop dead, I'm like, no, dear, no. You need him to stay alive and healthy and retire, because you get nothing. In a lot of these pensions, you get nothing. If he railroads same way. Tier 1 railroad,
Capers isn't like that, is it?
she testified, and we all knew that if he dies before retirement, she gets nothing.
All right, let me go back to this issue about execution. The judgment is entered by the district court, granting her a half interest in his pension at that time. That is a vested interest, right? It's contingent on some things to happen,
Correct,
but it's vested. It's not like a
correct.
future interest of,
And it's not like she has to do anything else.
exactly. Okay. All right. Now we now have a judgment that needs to be executed on within the next 5 years before it becomes dormant, or within the following 2 years so that it can be revived. Is that right?
I disagree with that,
Why is that?
because he can't, what if he doesn't retire in that 5 years or that 7 years?
No, okay, I understand what you're saying. Well, she can execute on it to the extent of perfecting her interest by alerting capers that interest exists, and that they're not to distribute the money to him. After all, if they don't know about it, he retires and he has choices about how he takes his pension. He could say, I don't want it in monthly, just write me a check and I'll take the whole thing.
Correct. And that would have been a risky, that's where the risk would have run. And I wish I would have had the wherewithal to ask Ms. Billings what the scenario would be if they couldn't find the alternate beneficiary, or they knew she existed. Capers knows what they're doing. When an employee of a school district marks married on any of their retirement accounts, they have to fill out forms, and they have yourselves as beneficiaries and retirees and potential retirees and past retirees who don't know what the word retirement means. That was directed at you, Judge McEnany.
Well, I think, let me.
You fill out forms that mark you're married or you're not married. Capers knows this. They knew there was a spouse out there. I have every belief, and I wish I would have had the wherewithal, the brainstem to ask Ms. Billings what happens if a retiree retires and you don't know about the divorce decree. I suspect she would, because I've gotten calls from Capers saying, hey, do you have a decree, or an ex-spouse that says, hey, Capers needs a copy of the decree.
I'm confused because it was my understanding of Ms. Billings' testimony was that after dividing it up and then him getting any further contributions to the plan or growths on his share of the plan, and she gets hers, I guess she assumes she gets growth on her share of the plan too, interest on her share of the plan.
Yes,
It was my understanding she testified that the wife gets her share with interest when the husband retires, dies, or withdraws from the plan.
correct.
So it's not totally dependent upon retirement. She testified that if I understand it correctly, that when he retires, dies, or withdraws from the plan, she gets her money.
I don't think that's how that works. She might get her money if he withdraws from the plan and takes an interest. But I know that he doesn't. I believe I asked her the question later on
All right, well, we'll check it.
that if he dies, she gets nothing.
Counsel, let's get back to Larimore for just a second. It seems to me the principle of Larimore that is being argued today is these division of pension assets are judgments that are subject to the 5 years plus 2 years, the dormancy and extinguishment. Is that something that we should adopt? Or are we bound by Larimore's principle in that or not?
You can be bound. What I say, my position is that Larimore doesn't come into this discussion because the judgment was entered at the time of the divorce. So when Judge Elder entered his decree, that's when the judgment was entered and perfected her portion of the retirement account to the satisfaction of Capers.
And then there's been no execution on that for this plus 7 years. For 7 years, correct?
Correct, because he hadn't retired yet.
Pardon.
Mike Francis has the same clucky thing. The duck hunters.
Well, thank you. Any other questions? Your time has expired. Thank you.
No worries. Thank you.
You've got 3 minutes, counsel.
All right. One point of clarification I wanted to make, the court had questions about if my client were to die, if the respondent would still have received her portion. The answer is yes, she would have still received her portion had she delivered this decree of divorce to Capers. They set aside, essentially they split the accounts. She has her own account, which is hers, whether he dies, retires, whatever, that's hers. And that's part of the reason why it's so important that she went ahead and delivered this decree of divorce / quadro to Capers.
But that's all done by Capers officials after they receive notice of the divorce.
After
correct?
they receive notice of the divorce, that's correct. And so I think this court really nailed it on the head. Is ultimately this case is about the execution of a judgment, 60-2403, which, as I said before, be it fair, be it not, be it harsh, be it not, let's put it that way, does require strict compliance with that statute. And this judgment was final the date that Judge Elder issued it. This judgment was not ever executed, was not garnished. There was no aid in execution. There was no revival. There was nothing pursuant to that statute to get it to Capers and to preserve that judgment for her with Capers. And so really the analysis on this case is very simple. I know we try to sometimes complicate things in the law, but sometimes things are just very black and white and very simple. And this is really just an issue of not executing on the judgment that she was granted.
Well, the
so-
problem is, it's kind of unique in this situation that you can't execute on the judgment the way you typically would. If the judge
Right.
said, you have a judgment for $50,000, send the sheriff out and attach or slap a garnishment on the bank account and get the money.
Right.
Because you're not entitled to it at that point.
Right.
It's all contingent upon these other things having happened.
Right. And so maybe this is an oversimplified way to equate it, but I would almost equate it like filing a lien on a car. That puts people on notice that there's a lien on the car, so that if they, for example, Mr. Holiday wants to retire, somebody's put on notice that she has this interest without that actually being delivered to Capers. They're not put on notice. And as someone here said earlier, what would have kept him from just retiring and taking out all this money? Well, nothing, because Capers wasn't put on notice because she didn't take this final ministerial task, if you will, to preserve her interest with Capers.
Thank you,
All right.
counsel. We will take a short recess now and rearrange the nameplates and take up the next case in a few moments, about 5-6 minutes.
That's what she always wanted. Yeah.
Figured it out. I was gonna check today to see.
You may be seated. Thank you. I'm Chief Judge Karen Arnoldberger. I'll be presiding over this case today. Do we have somebody we're waiting for? Or?
Yes, I believe we thought we were taking a 5-minute break, so we just ran to the restroom.
Oh, we weren't on 5 minutes. I guess we didn't pay attention. All right, I'll wait just a few minutes for him. Judge Hill already did the introduction, so I won't do that today. My job as presiding judge over this panel today is to keep time. And you'll find out that I am really woefully inadequate at that. And so you will end up probably getting a lot more time than your 15 minutes because I get involved in the argument and forget to look at the watch. So but I'll try my best. And I'm very happy today to be able to sit with Judge Coble on her first docket, becoming a judge. So. All right, so I will call case number 124679, Davis Hammett appellant versus Scott Schwab, Kansas Secretary of State. The parties would state their appearances, please.
I'm Josh Pearson for the plaintiff, Davis Hammett. I'm joined at the council table by my colleague Sharon Brett.
And will she be making any argument or, okay, all right.
Honor, may I please the court, Clay Barker, General Counsel for the Office of the Secretary of State, representing Scott Schwab in his individual capacity as the Secretary of State.
Okay, thank you. And I see this case does not have additional time, so we have 15 minutes per side. Mr. Pearson, do you wish to reserve any time for rebuttal?
Yes, Your Honor, 3 minutes, please.
3 minutes for rebuttal. Okay. All right, we have read your briefs. We are very familiar with the facts of the case, so you don't have to spend a whole lot of time on that, although this is a pretty fact-intensive case as it is. Just know that we have read those briefs, and so you don't have to take a lot of time to do that. All right, Mr. Pearson, you may go ahead and proceed.
Thank you, Your Honor. May it please the court. My name is Josh Pearson. I'm an attorney with the ACLU of Kansas, and I represent the plaintiff, Davis Hammett. Your Honors, Mr. Hammett and his organization, Loud Light, work to ensure that all Kansans who are eligible to vote are able to do so. As part of these efforts, Mr. Hammett sought publicly available information about who was forced to cast provisional ballots so that he could help ensure that those people were able to vote. Despite these noble but simple goals you might expect the Secretary of State to share, the Secretary's office has fought tooth and nail to undermine Mr. Hammett's efforts for years. It's why we're here. The Secretary's deliberate and hard-fought campaign to close access to public records and keep information about who cast provisional ballots and why in the dark.
The district court referred to a prior case. Can you tell me a little bit about that one?
Yes, Your Honor. So the parties have litigated before. This is the second time they've been in court together in Kansas. The first case concerned Mr. Hammett's original requests for these provisional ballot information data. The Secretary opposed that and claimed that under the Help America Vote Act, the federal law which requires provisional voting, that this information was confidential. The information about who cast provisional ballots and why. The district court disagreed and ordered the Secretary to turn over the information, finding that the provisional ballot data was in fact subject to QORA.
I understand then a report was handed over.
That's right. More than one, actually. So after the judgment in July of 2020 that's right. So July of 2020, the district court entered its order. The Secretary complied, turned over the provisional ballot detail report.
No, excuse me for a minute. And that detail report is what the district court judge found was open public record.
That's correct in that case. That's correct.
And that case was not appealed.
That's correct.
And the state does not challenge, it's my understanding, the fact that that report is an open public record.
That's correct. There's no
So
challenge.
that's a done deal.
That's right.
Okay, thank you.
But back to your question, Judge Hill, Mr. Hammett then made a series of further requests, as he told the Secretary he was planning to do. Two of those requests were made in August of 2020. The Secretary complied with those requests, and within 2 days of Mr. Hammett's last request in August of 2020, the Secretary instructed its technology provider, electronic ES&S, we call it, electronic systems, to close the records and to make it impossible for the Secretary to provide provisional ballot detail reports in the future.
And if I understand the papers correctly, this was done by changing the program. So you don't have to just push a button to get the report. You'd have to revise the program to now get the report. Is that correct? Or am I misunderstanding?
I think yes and no is actually the answer, Your Honor. So the Secretary certainly claims that now he can no longer access the provisional ballot data. So this data still exists. The information about who voted provisionally and why is still available to the Secretary, is still in the state's public database. Now, according to the Secretary, he can no longer run the provisional ballot detail report, which, as you suggest, was a click of the button, a very simple process to get the information.
Well, but let me stop you there. On the prior information, how much did that cost your client to get?
Before the Secretary changed the system, it was free.
Now, it's going to cost you how much? $595?
500, the secretary wanted to charge Mr. Hammett $522 for this specific request and an unknown amount for each request into the future.
So what was free before now costs you $525 or whatever.
22, but yes, according to the secretary, though it's important to note, and I don't think the secretary really addresses this point in their briefing. The secretary, it's in the stipulated facts. It's paragraph 50 of the stipulated facts that the parties went to summary judgment on. The secretary can ask ES&S to simply turn back on the provisional ballot detail report. So he still has access to this information. As I said before, the data still exists. It's still available to him. It's still his data. It's the state's data. And all he would need to do is ask ES&S to reverse the decision he instructed them to make in the past. So what the secretary offered Mr. Hammett was to have ES&S write some special code to retrieve this information, but that's actually completely unnecessary. The secretary could simply ask as a technology provider to undo what he asked them to do originally.
So basically, he's saying you have to go to the vendor to get the information, and they'll have to write some special program separate and apart to get our state data.
Essentially, yes, that's correct.
And I have another question here. I just want to make sure I'm understanding this right. I have a little bit of experience dealing with computer programs and changing computer programs. And so this Elvis system, it's my understanding, is a nationwide system, basically. And so each state would contract with this vendor that provides this program. And this program is probably pretty robust. There are things in it that some states use and some states don't use based on their law, but the vendor doesn't key each particular item in the Elvis report to each particular state.
That's correct.
Mostly, maybe some things. And in this Elvis system, there are lots of reports, some of which the Secretary of State's office may use, some of which it may not. But the program gives access to all of those reports. And it's my understanding that what happened here is, and that access remains today. And as far as the program, the functionality of the program remains the same.
Yes, Your Honor.
All that happened here was the Secretary of State said, don't give me access to that report anymore.
That's exactly right.
Because if I don't have access to that report, then arguably I don't have to provide it to anybody else.
That's exactly right.
Okay,
That's exactly right. And
I
I
just want
think
to make sure I was correct there.
I think what Your Honor was getting to as well, we actually know from the record that not only did the secretary ask ES&S to turn off this one report, he did so for the purpose of not having to respond with Mr. Hammett's requests he knew were coming, requests that Mr. Hammett had told him were going to be coming. And from he doesn't even deny that. There's an affidavit. Go ahead. I'm sorry.
And that's where motive comes in. And the district judge said, motive is irrelevant here because the statute does not require him to provide a report that he doesn't have access to. Is that right? Why is the district court wrong there? Why is motive important here?
Yes, and so for two reasons. I think when it comes to motive, the simplest answer is the reasonableness of the fee. So it just under the section 219 of the statute, the government agency, in this case, the Secretary's office, can only charge a fee for copies that's reasonable in the actual cost of producing them. It would be reasonable would be meaningless if government agencies are allowed to purposely incur costs for the purpose of discouraging requests. There would be no reason to have the word reasonable
But
in the statute.
what cost is the state incurring? What cost, if all he has to do is ask Elvis or the provider election system software to turn it on, what cost is that to the state?
Well, so I don't think the state reckons with that argument. The Secretary's office does not acknowledge that it can simply ask ES&S to turn the system functionality back on. Instead, they say, from our point of view, erroneously, that ES&S has to write this special code. But even under that framework, it's a special code they have to write entirely because of the Secretary's targeted closure.
Thank you.
I think also, besides simply the reasonableness of the fee, the motive should still matter under the sort of what I call the operative provisions of CORA, section 218, section 219. So those are the provisions that say government agencies have to keep open public records. And it simply runs counter to the explicit purpose of Quora, that government records be open. And especially in this context where it is about something so fundamental, it simply runs counter to the statute if government agencies are allowed to purposely close records strategically in the sort of gaming kind of way in order to keep requests that they know are coming from being fruitful. So I think admittedly, the reasonableness of the fee is the easier argument when it comes to the motive of the secretary, but I think it also matters when it comes to the sort of more fundamental operative sections of the statute as well.
And would it be your position that if motive is material in this case, which the district court found it was not a material issue, if motive is material, then summary judgment is not possible because you've got a dispute?
Well,
I mean, you've argued, and there's a stipulation for purposes of summary judgment as to the relative facts that took place, but there was some argument on the part of the Secretary of State that there were other reasons, that this wasn't entirely a nefarious motive. So that would put a question of fact into issue.
I think at the least it was a question of fact and issue. At the least it requires reversal of the district court's judgment for further proceedings. I do think the record is actually quite clear about the secretary's motive, that it is not a leap or an inference to say that the secretary intended to do that. We know that actually from 4 pieces of evidence that are in the record. First is the timing. Like, as I just mentioned, 2 days after Mr. Hammett's most recent request, only weeks after the judgment. The secretary has admitted that he doesn't want to produce these records, not only by litigating in the first instance, but then publicly to the media. He was very clear about what he thought about his obligations under Quora, about the openness of these records. We also know that, as we talked about already, that the secretary only instructed ES&S to remove this function. It was not some benign record keeping function or record keeping reprogramming. It was specifically targeted to the one that made Mr. Hammett's request possible. And then finally, it's the undersecretary's affidavit in the summary judgment material. He all but admits that this function was only used to respond to Quora requests. He admits that the secretary didn't learn about it until 2019 when Mr. Hammett was asking for this stuff. He admits that the last time they used this function, the provisional ballot detail report, was in response to Mr. Hammett's Quora requests. And so when they target this particular request or this particular function that was only used to respond to Mr. Hammett's requests, I think it is clear as day why the secretary did this. I don't think that's a question of fact. But yes, Your Honor, I agree. The simplest, certainly it is at least a question of fact.
So what are you asking us to do? Simply reverse and remand for reconsideration, or are you asking for any other kind of relief?
Well, we are asking you to reverse with instructions to the district court to enter summary judgment in our favor. Alternatively, we ask you to reverse and remand with instructions for further proceedings. I think we've sort of covered, much of it. I do want to, on the reasonableness of the fee, there's a helpful Attorney General's opinion. It's 87-4 that talks about the purpose of the amendment to the statute, which included that reasonableness language. The purpose of that amendment was to prevent exactly what happened here, to prevent government agencies from purposely encouraging fees that had the effect of closing records. Exactly what happened here. And then it's Professor Fredrickson's article that we cite, that both parties cite, I believe. He talks about Representative Neil Whitaker, who was one of the legislators who enacted that change to the law. Representative Whitaker was explicit about that being the purpose of the reasonableness provision in the fee. So it should be very clear that the purpose of the prohibition on unreasonable fees, if you will, is to prevent exactly what happened here, the effective closure of records. And I want to make one final point too, that so while the provisional ballot detail report that the secretary makes much of, we no longer have access to the provisional ballot detail report. So it's no longer a record in our possession. But it ignores the fact that this information is still in their possession. They don't even dispute that the provisional ballot data, the people who voted provisionally, the reasons why, all the information that gets put into Elvis in the first place is still there. What they have done is effectively close the door to the warehouse and thrown away the key. So the information is still there. The information and the data is still available and in the possession of the secretary. So even if you were to take their position that the provisional ballot detail report itself is no longer a document that they have access to, the data itself is still in their possession. Unless there are further questions.
I'll give you a little additional time because we've asked a lot of questions. Does anybody have anything else? Okay, thank you. You'll still have your 3 minutes.
Thank
for
you, Your
rebuttal. Mr. Barker?
Your Honor, thank you, Clay Barker, for the Secretary of State. We're asking the court to affirm the summary judgment issued by the district court on both counts. One, that there was no violation of CORA for turning off an optional report of functionality that could produce it, and second, on the reasonableness of fees. And if I have the time, I'd like to go through 4 points in my argument. First, why this case presents 2 somewhat novel issues to the district court. The second is the framework the district court used, which I would suggest for this court, and explain why that framework came to the correct decision, especially why motive is completely irrelevant in this case. And last, I'll touch on the reasonableness of fees. And 2 facts I'd like the court to keep in mind. One is nothing in Kansas law requires anything about recording provisional ballot data for individuals. This report is completely optional. And as the facts show, it's
At whose option?
the counties. The state has nothing to do with creating the report. The counties input the data. They do it in 105 different ways. Many don't bother using this report different times. It's really the facts show, a notepad for counties to use. The state can summarize in one total report if the functionality still exists.
So is your position that if the state collects data that it's not required to collect, that's not open, that's a determinant as to whether it's open or not?
No, Your Honor, and what we believe is determinant is 2 factors, and this is the analysis. If the report is mandatory, stated out in law, then the agency must produce it. If they don't have a function to produce that report, they have to create one. It's a different analysis if the data is optional. If the agency has a way of producing that report, either it's a functionality or it's a document in a file or an email,
And
PDF, then they
all
have
this
to.
is the Secretary of State's program, right? The Secretary of State purchased that program and is in charge of the program.
Correct, Your Honor.
And do you tell counties don't input provisional ballot data? Is there a policy on the Secretary of
There-
State's?
Sure. There's no policy at all. It's
Okay.
optional for the
So-
counties.
So counties input provisional voting data as a part of the record for the voter. So of that particular voter. So for example, I can go into my record on the Secretary of State's office, look up my name with my date of birth, find every time I voted in an election in Kansas, as well as whether or not there's ever been a provisional ballot filed. I've ever had to file a provisional ballot.
You know, for individual record voter, you can determine if a ballot was provisional. It would
Okay.
not include what's in this report, which is why the provisional ballot had been deemed provisional and whether it had been cured. or
But the
not.
counties are including that. So they are required to put in whether or not that voter filed a provisional ballot. Just not, you're saying they're not required to put in the reasons that the provisional ballot was necessary.
You know, they're not required to record anything about the provisional, but
They
they
do.
will. When they do it, it ends up in the voter's individual record.
Okay. And has the Secretary of State ever advised them not to do that?
No, Your Honor, it's
And the Secretary
completely,
of State is well aware that they do that routinely.
yes,
Okay.
it's
Thank you.
completely their option. And as I said, many counties don't bother with this report. It's a work pad they erase after the election.
Right.
And the other key fact, Your Honor, is at the time this functionality was removed, there was no outstanding CORA request. It was just a prediction.
And it was removed admittedly at the direction of the Secretary of State.
Yes, Your Honor. So about,
I don't want you to do this anymore. Take it off so I don't have access to it.
yes, Your Honor, about 2 weeks after the district court said the exemption from HAVA does not apply to the report. That was the first case. It was about an exemption, then the functionality was removed.
So it looks to me that he lost the action in court. Says, well, we'll just not collect this anymore. don't have, it's as a result of the lawsuit. Is that what you're telling me?
Your Honor, the lawsuit was part of it, and this is where we believe motive is irrelevant, and it's not been factually developed, though the Assistant Secretary of State for Elections stated in his affidavit, the report is inaccurate at state level and leads to public misinformation.
But if we disagree with you and motive is important, then you can't have summary judgment. You have to have some sort of fact finding, don't you?
Unless you agree that it was, the motive was to prevent this, Mr. Hammett from getting this
No,
information.
Your Honor, we would not agree to that. If the court does find that a government agency has to have a motive to change a completely discretionary record, it'd have to go back for further fact finding.
I do have one other question for you, Mr. Barker. You represent the Secretary of State, and you did represent the Secretary of State in responding to Mr. Hammett's open records request, correct?
Yes, Your Honor. I'm the Cora officer. I was not the attorney at the district court level, but he left and I took it
Okay.
over with you.
But you're the one who responded to Mr. Hammett finally and said, we're not going to give you this information. And you said, we're not going to give you this information because Elvis had a major overhaul requiring the system to be offline for 3 days. And when they did that, we lost access. So you basically were saying that we don't have this because there was a major overhaul and Elvis doesn't collect that data anymore, so we don't have it. And that was not true. Is that correct?
No, Your Honor, that was completely true. The system was taken down for 3 days for a major overhaul. One piece of that was removing this functionality.
But you only made it appear that it was because of this overhaul that the functionality was lost, that it had nothing to do with the Secretary of State requesting that that be removed. Trying to see the exact language here you used. I have the letters here, but and it wasn't until sometime later, and Mr. Hammett indicates this in his affidavit, it wasn't until sometime later that it was discovered that this was not an Elvis issue. This was a Secretary of State issue, removing the report. It wasn't anything that Elvis did that made that report unavailable. It was only the secretary requesting that it no longer be available that made it unavailable.
Correct, Your Honor.
Right. But that's not what you led Mr. Hammett to believe in your initial response to his request, is it?
Well, Your Honor, there would have to be additional fact finding if you want to dig into that because there were.
Yeah, I'm just looking at the emails.
No, Your Honor, we informed him that because of the removal of the functionality, which occurred during the 3-day shutdown, we could no longer produce this report.
It says the KSOS office can no longer see the accumulated data or generate the report because of this major overhaul to the Elvis system. And that's not completely true, is it?
I believe it is, Your Honor. The
Okay.
3-day shutdown was, removing the functionality was one minor part of the 3-day overhaul.
But the functionality, removing that functionality had nothing to do with the overhaul. They were two completely separate events, correct?
They were done contemporaneously, Your Honor.
Okay, all right. If you want to stand by that, that's fine. Go ahead.
And Your Honor, two reasons the district courts, that were two issues that were unique to the district court that there's not a lot of case law on was, first, at the time this request was put in, there was no report. We're not arguing about an exemption, a little bit on fees, but public agency, retention schedules. That's not the issue. There was no report at the time. There was no ability to generate it. And the district court correctly found you can't have a Cora violation if there is no report to produce. And second, that this involves a database where most of the other case law and the statute itself, which was written in the 80s, seems to apply to, it was written in mind with paper documents or electronic documents that are in final form, not a database where the data can be anywhere and it doesn't turn into a report or a record until a report is generated with particular data in a particular format.
Hey, Mr. Barker, I'm sorry. I'm going to go back to this because I did find the email. It says Jameson and I just met about this. He could not get Elvis to produce the report. We went and spoke with Brian and learned that on September 11th to 13th, October 14th, you're saying we just learned that Elvis was taken down and ESS implemented a substantial upgrade to prepare for the 2020 election. As part of that, many functionalities at the state level were removed. The provisional ballot report was one of them. Well, it turns out that that was the only one. Is that correct?
No, Your Honor, not to my knowledge, that there was a lot of changes made to the system.
Okay, and until 20 minutes ago, I was not aware of that. So on October 14th, even though the secretary had requested in September that that report no longer be allowed, on October 14th, you as a representative of the Secretary of State said, I wasn't aware that that functionality wasn't there anymore. But the secretary was certainly aware it wasn't there anymore because he requested it to be removed back in September.
That's correct, Your Honor. It was
Okay.
removed and I was not aware of it, and neither was the assistant election Jameson.
Okay. So the secretary did this without discussing it with anybody on his staff. He just called them and said, remove it
No,
as
Your
a
Honor,
singular action.
the secretary worked with the elections and IT staff and
Okay.
asked that it be removed as part of the 3-day shutdown.
Counsel, if I may, I'd like for you to talk about the reasonableness of the money you're requesting to get this report made. The went from $0 to $522. How did we get to the $500? How did that estimate come about?
Sure, Your Honor. It's our normal policies, even though we could charge for core requests, that we usually don't. So we don't bother with assessing staff fees and passing it on and getting paid first and then producing the record. And in this case, since we had no access to this data anymore, this almost seems like an example of no good deed goes unpunished. We informed Mr. Hammett he could go to the counties and get this report. That was always available to him. This was never closed off and shut down. And the county report is actually accurate for each county. We went to the vendor and said, is there any way you could pull this report for him because he wants it? And they came back and said, it will cost you $522 because we have a contractual relationship and we can produce a script that can probably pull it, but we can't promise it'll be done in time because the election was going on at the time. And so we decided, because our office would have to write a check for $522 to the contractor, that we would pass that cost on to Mr. Hammett and not add on any staff time. That's why it would be a reasonable fee.
All right, thank you. Now, how your opposing counsel said all you have to do is turn this back on, the function back on.
Well, one, Your Honor, this is a completely optional report and the secretary doesn't want it. He doesn't need a motive to control his own file system.
Right, so it seems to me that a report that Mr. Hammett obtained for free, now it's going to cost him $522. Is that within the spirit of the Cora?
Your Honor, I think within the spirit of Cora is trying to find an alternative for him. But during the election, it would be very unwise to touch the software. Because remember, this is in October when the advanced ballots had already gone out. No one was going to try to change a functionality in the election software during the election. Afterwards, it might be different, but the cost to get it during the election run-up would be $522, and we couldn't even promise that. It was a possibility.
And that's important too, isn't it? That you couldn't even promise that, as far as the plaintiff's argument that he was in essence denied access, because timing was important here. Because after the election, it's overwritten and that information is gone and you're on to the next election. So by saying you have to go to each county and you have to go to the vendor, or you have to go to the vendor to have them write this special report that they can't guarantee when they'll get to it, in essence, he's not going to get the information, just timing wise. Not going to be possible.
Your Honor, he could go to 5 counties and get half the voters in Kansas.
Mhm.
But I'd like to return the court to what we think is the key issue here. This report is not required at law anywhere.
Right.
The secretary has to have, and any government agency has to have the ability to change how they work with non-mandatory reports. They could eliminate them, add to them, modify them, change them. And we can't just be hijacked and frozen out because someone has a potential future Cora request. We know requests will come in every election, but we need the ability to change the optional reports. And this framework I was discussing, essentially, if a report is optional and you have access to it, there is a functionality, you must produce it. No question about that. And that's what we did when we had access to the report. But if the secretary decides, using his discretion, that he no longer wants this optional report, then he can get rid of it. And if we don't have the access to it, then we don't have to produce it.
Yeah, let me give you a hypothetical. There were lots of hypotheticals in the briefs about emails and what if a governmental agency decided, well, we're just going to stop the search function on emails to make it more difficult for people to find emails that they're looking for on a particular topic. What if a city council has a program that allows their meetings to be recorded? And it's all digitally recorded, placed into a system. And reporters can't go to every city council meeting all over the state, so they rely on going in the next day or several days later to listen to this recording. And what if the city council decided, well, we're going to record the meetings, but we're going to turn off the ability to provide this to the public to listen to the meetings. We're going to turn off that functionality. Is that fine for them to do that? That's not in violation of Cora, or because they're not required to give people copies of an audio of the meeting, but they have an audio of the meeting. But they just decide they're going to turn it off so that reporters can't listen to that meeting the next day. Would that be okay? Because they're not required to do it.
Hypotheticals are always tough.
I know.
I'll assume that there's no requirement that they do any videotaping at all.
Right.
But they have it, so it's in a permanent fixed format, so they
Right.
have access to it.
Right.
Here, there was no permanent fixed format report. We had no access to that.
But you had all the data. And, all right, okay.
And Your Honor, this again gets to a database issue that doesn't appear with other electronic. What is the record? Is it the data or is it the report?
And the district judge used the term functionality a lot. This is a functionality we no longer have. But you do have it. You've always had it. You have it today. You've just elected not to use it.
We no longer have it, Your Honor. There's no more drop-down menu to produce this report. We couldn't.
Because you
produce it.
decided to turn it off.
Correct, Your Honor.
But it's there. It's still there. It's still in the software. Election systems and software hasn't taken that out.
They have.
It's a massive program that an off-the-shelf program. It's still there. It may be hidden, but it's still there.
They removed it from the state level access. It
Right.
still exists at county, which is a different.
You're saying,
functionality.
are you saying today that they removed that data?
Your Honor, the data is there
Still there.
and put by the counties. The
Right.
counties have access to it. At state level, we have different functionalities for this database. County and state are very different in how they use
Right.
this data. We no longer have access to it. We can't create the report.
Counsel, what if we were to rule that the data is the record? And all of these other reports are just simply reports. But the data is the record, and that has to be open.
Your Honor, that would raise many interesting aspects for jurisdiction. Since if the data is the record, then you can only bring a case in the district court where the data exists, unless you also want to say where you can produce the report is also the record.
Well, where does the data exist? It exists in the ether somewhere.
Exactly, Your Honor.
It doesn't reside in Topeka or Wichita or someplace else. It exists in the cloud.
And Your Honor, if that was the decision, I believe a lot of state agencies would immediately review their databases and start removing a lot of optional data because they wouldn't want to be compelled to create reports. Essentially, then you're creating reports, which is what the Attorney General's opinion says Cora does not create a duty to do.
How are you creating a report that already exists? This is a report that exists in the database from the election system software. This report is there.
Your Honor, I'd argue the report isn't there. The underlying data is there, but it has to be, certain pieces are pulled out and put in a certain format, and then that creates a record.
Okay.
And again, Your Honor, this is where I said this case presents some novel issues. there is no fixed report that exists, and it involves databases, and Cora really wasn't written with databases in mind. And I think even the plaintiffs alluded to that in their brief.
I'm sorry, we've asked you a lot of questions. You're over your time, but I'll give you a few more minutes.
Well, Your Honor, I think these are excellent questions because this issue is novel and it does need to be decided, in which the legislature would actually resolve it. But whatever the court does is going to cause a chain reaction through state government of one way or the other deciding what they're going to remove, what they're going to record, and what they're not going to record.
And if we were to,
Won't be the
let's,
first time that that's happened.
well, let's hear what those parade of horribles would be.
Yep.
Let's say that we decide that this report, as Judge Watson found back in 2020, this report is a public record, that public record was maintained by the Secretary of State, and that motive was important, and that the Secretary of State purposefully impeded access to that data that was contained in this report by turning that report off. What are the parade of horribles that will follow from that?
Well, I wouldn't call it a parade of horribles, Your Honor. It'd just be a reaction agencies would have to examine.
Would have to do what?
But I'd first like to correct the first case. We never argued it was not a public record. We just
Right.
argued there was an exemption.
Okay,
Because
but I
we
mean, but we're not arguing that now because it is a public record. You haven't challenged that. The district court found it was that report was a public record. That's
While
kind
the
of the law of the
functionality-
case, isn't it? I mean,
While the functionality existed, it was a
Okay.
public record.
all right.
Once the functionality goes away. But I guess the core, I wouldn't call it a parade of horribles. The core issue, Your Honor, to answer your question is there's this large amount of data with no functionality to pull pieces of it out and create a report. If you're saying that a Cora requester can get anything in that data, then they could simply say, I want a report that says this, and this, and you need to create a function to pull it for me. Now, if it's a mandatory report and there's thousands of them in the statutes, then the agency must have a way of pulling that.
So I guess you're saying there is a functionality exception to Cora.
I would not call it an exception, Your Honor. I'd say there's just no record. It would be as if the database said,
A functionality is not a record.
correct, Your Honor, the functionality is what creates the record from the data.
Functionality creates the report.
Sort of like having a form that can be.
The
filled out.
functionality creates the report. It doesn't create the data.
Correct, Your Honor.
The functionality reports the data.
Correct, Your Honor. And that creates the record that's requested. And some.
And so because the Secretary of State said, I don't want to see this anymore, that's no longer a record.
Correct, Your Honor. Secretary of State said this is an optional report.
So it was what we have to decide is that the reasons for doing that are within the spirit of Cora.
You know, I'm not sure if the spirit of Cora is the right way to put it. If an agency does not want to keep or wants to modify an optional record,
Then shouldn't we hold them accountable for why do they no longer want to do this? Wouldn't motive for making a report no longer available be important? And if so, we're at summary judgment here. We don't have any facts. It seems to me that you can't escape motive if that's the case.
you know, I respectfully disagree. If it's an optional record, motive is irrelevant. It's the agency, the secretary has complete discretion in what they do with their optional records. And again, expand them, change them,
So
eliminate them.
Cora only then depends upon the office holder.
No, Your Honor, there's mandatory reports, which is the vast majority. Those have to be produced. There's no question about that. And if the agency has access to the report, there's a functionality, it's stored on a computer in a file, that must be produced. But if it's optional and the agency no longer wants it, there's no duty to produce. Cora wouldn't apply then. It's as if I had kept a spreadsheet on my laptop where I was recording some government information and someone found out about it and Cora'd it and I produced it and said, I'm not going to keep this up anymore. And I stopped, they could come back and say, no, you have to keep doing that.
But you're not the Secretary of State. You're not the office holder, and you're not the one that's responsible for keeping public records. Interesting.
If this is a discretionary function on the part of the Secretary of State as to whether to keep these records or not, don't we look at whether or not that discretion has been abused? And wouldn't motive go to whether that discretion has been abused? Is discretion just, it's his discretion, you can't challenge or question that?
Your Honor, I would argue that for optional reports, just reports or data that there's no requirement to keep anywhere in statute or regulation, then you can't have an abuse of discretion. It's the agency's creating its own filing system and constant process improvement, adding, taking away, going through old files and throwing out things you don't need. Now, if they're, again, mandatory, you have to produce it. If you have access to it, if a core request comes in and there's a file that you were about to shred the next day, you have to produce it. But if it no longer exists, then there's no duty under core to produce anything.
So, counsel, if the court were to find this was a public record, Cora does allow the custodian to refuse to produce it if it places some sort of unreasonable burden on the Secretary of State. What sort of burden is it to the Secretary of State to simply turn this functionality back on?
Your Honor, probably not a lot of burden to turn the functionality back on now that the election's off. But the unreasonable burden applies if the secretary would be produced. It's a mandatory record, for instance, or something we have possession of where it's just hard to produce it. And at least the Attorney General's opinions are that's a standard so high no one could probably ever meet unreasonableness of the burden. But when it's a discretionary record, doesn't matter what the burden is, the secretary doesn't want to produce it, the report anymore, then that's completely within his purview. These are optional data that is not required anywhere. There's lots of optional data out there. I'm sure I could come up with a report from the Elvis system that pulls discrete pieces of information that hasn't been asked for yet, where there's no fixed report, but one could be created. A functionality could be created to pull it.
Right, and if someone has the Elvis manual, which the record shows that Mr. Hammett certainly had.
We produced it to him, Your Honor.
To look and see exactly what kind of reports Elvis produces, and you haven't turned them off, he could certainly request any of those reports.
Absolutely, Your Honor.
Okay. So if there are things you do not believe you should be keeping or should have reports of or don't need, wouldn't it be incumbent upon the secretary to go through when you're installing a program like this and get rid of what you don't need and keep what you need?
Yes, Your Honor, but we have to remember the manual can apply to both county and state, and there are reports that only the county actually uses or can pull. Some only can be done at the state level. Most overlap to some degree. Again, like this report is still available at county level if they decide to use it.
Any other questions?
Thank you, Your Honor.
Mr. Pearson.
Thank you, Your Honor. So first, this case isn't about creating some new report. It's about the secretary's destruction of a report that he already had, in which he can simply ask ES&S to turn back on. There's no creation here of any kind. I want to address this.
Is there no dispute that that's all that needs to be done? He can just go in and say, turn it back on.
That's correct. Again,
that's not disputed.
That's right. Paragraph 50 of the stipulated facts. This mandatory versus optional distinction that we just heard so much about, it simply isn't in Cora. It's now 217J, I think it was 217G at the time, the definition of public record. There's no distinction between whether or not the secretary has to produce this report or has some other lawful obligation to keep the report. It's just whether or not any recorded information, regardless of form, characteristic, or location, which is made, maintained, or kept, or in the possession of a public agency.
That seems pretty broad.
That's right. It is.
Does that include data, no matter where it's located?
Absolutely, it does. And it would, absolutely, it does.
Now, what if you had somebody that came into the Secretary of State, says, I want some particular amount of information that would require then an overhaul or reprogramming of the computers? Would the secretary have to comply with such a request and spend thousands of dollars to have the program done so they could make one report?
Well, so that hypothetical, which is not the case here,
Right.
there may be some argument about the.
Would that be reasonable?
Potentially, I think it would depend on the facts of that case. We actually know it's the Stephen v. Harder case. It's 1982, a venerable case. In that case, the court held that this redaction that was required in that case, it was medical records that had some Cora-able public information, but also had private patient information. The court actually in Stephen v. Harder held that the government agency did have a responsibility to write a program and make that, and that was a much different time when it came to computer technology, obviously, but write a program and make the redactions possible so that they could turn over the publicly available information, but protect the private confidential information. And that program at the time was, I think, in this case, around $2,000 or $3,000. And the court in Stephen v. Harder held that that was Cora-able, that was reasonable. They could do that, but they could pass along the information. That's because it was the only way to do it. Unlike here, where there are ways to do it that aren't that expensive, that aren't expensive at all potentially. And also there was no evidence or argument in Stephen v. Harder that the state intentionally added confidential information in order to hide the records, which is essentially what happened here.
Counsel, the district court used the term functionality frequently in her opinion. Did she create a functionality exception to Cora? So if it's a functionality, you can't request it. In other words, if you don't have the function, you can't request it. It's not under Cora.
Yeah, so the district court certainly relied on that characterization when she decided that the secretary was right here. And I think this actually gets to it's a nice point about this, a second argument we heard a lot in the secretary's arguments about how unique this is, how it's a database, and so that's so unusual. And to an extent, that's true. Obviously, when Cora was written, it's a very different time. This probably wasn't contemplated in some ways, but it has been clear since the 80s. Stephen v. Harder, that case again we just talked about, was what it said, that computer records themselves are public records. That's been very clear for decades now. And in fact, it's the AG opinion, it's 88-1-152, 88-152. So since 1988, the Attorney General's been of the opinion that the right to public records should include rights which arise from improved public record keeping. In other words, we should all benefit from the fact that data processing, computer record keeping makes it easier to respond to Cora requests, makes government transparency more available. It shouldn't be the improvements in information technology shouldn't give government agencies an excuse to further game and hide information. It should be the exact opposite. It should be that any improvement, that we should all benefit from those improvements together, not what happened here. Finally, I think I believe my opposing counsel mentioned something about that his office and the secretary shouldn't be hijacked or frozen out, or that some potential Cora requests might require them to keep records in perpetuity. And it's simply not the case here. This isn't some hypothetical Cora request. This isn't some random request for information into the future. It is a specific and known and particular request made by a particular person who the secretary litigated against for years now.
This data, though, comes and goes.
That's correct.
With each election.
That's correct.
You've got information concerning this series of elections, then it's gone because you're going to start a new cycle.
That's right.
So this is transitory.
That's right.
Fleeting at best.
That's correct. It's not so much that it's when the new information gets put in, which I believe is how it's characterized in the record. So I don't think it just disappears on its own, but when new elections arise and the counties re-input information, as I understand it, that it overwrites the information from before. Your Honors, thank you for your time. We would ask you to reverse the district court's decision.
Thank you very much. Thank you, counsel. I've allowed both sides way more time than 15 minutes because I do think this is an important case. We do have lots of questions we had after reading the briefs. So thank you very much. We'll stand in recess and we'll get an opinion out on this matter as soon as possible. Thank you.